With Arkansas Congressional District Maps. They continue to see challenges more than 2 years since their adoption. At least 3 lawsuits have made various claims that allege lawmakers gerrymandered them all to split up black voters. Now the plaintiffs in one of those cases are filing a new motion to keep their fight going. THV 11's Ian Russell explains.
It's not fair. It's not equitable. It violates Section 2 of the Voting Rights Act.
Every person on this Zoom call is here for one reason: Arkansas's Congressional District Map and what they say is wrong with it.
Filed a lawsuit challenging the newly enacted Arkansas State House map because it unlawfully diminishes the voting strength of black voters in the state.
To fully understand what's happening here, we have to go back 2 years ago to 2021. Lawmakers approved a map splitting Arkansas into 4 congressional districts, a heated topic, fragmenting Pulaski County into 3 separate districts.
It's a clear attack on voting rights and people of color. It is continuing to attack black folks and making sure they do not have fair representation.
Because of that, a lawsuit was brought forward, but a federal judge ruled that the lawsuit should be dismissed, and then an appeals court agreed. They say only the United States Attorney General can bring up this type of lawsuit under the Voting Rights Act, not private individuals. Those on this press conference say something like this has never happened before.
We're talking about decades and decades of a precedent, and all of a sudden, only the government can sue the government. You know, that doesn't even sound right when you say it out loud.
Something we haven't seen before.
Joshua Silverstein is a law professor. He says for the past 60 years, courts have operated on the assumption that the Voting Rights Act allowed both private individuals and the government to enforce Section 2. The tough part is the law here is a little murky. It doesn't expressly say private citizens can, which is why the district judge ruled the way they did.
But again, it's not as clear as under the antitrust laws, where there's an explicit authorization for suit.
Now, the plaintiffs here will petition the full 8th Circuit to rehear their case. As for what will happen after that, Silverstein says don't be surprised if this ends up going even higher.
My hunch is, whatever the en banc 8th Circuit does, the loser is going to appeal to the Supreme Court.
In Little Rock, Ian Russell, THV 11 News.
Ian, thank you. Now, the appeals court decision was only 2-1, with the dissenting judge pointing to decades of cases backing his opinion. That's one reason Silverstein, the professor, thinks all of the judges on the full 8th Circuit in St. Louis will want to weigh in. Now, if they overturn that 2-1 decision, then the case likely heads back here to Little Rock to actually be tried. And if they uphold the decision, Silverstein says then the Supreme Court may take a look at all this.